Was the sole topic?
No, it was a topic that was discussed in more than a fleeting way.
At the Mass Family Law Conference, the annual conference that took place just in the end months. It was March or May.
Okay.
I think it's March.
This past year.
Yeah, just recently.
Okay.
It was March because it was before I became aware of my nomination.
Now, regarding that item, have you ever, I know that you just said that you were regarding a lot of cases where there were custody determinations you made recommendations, and those cases, some of those cases involved domestic violence.
Or allegations of
domestic violence, right? Okay. And how many of those cases did you testify at trial?
I can tell you in the last 10 years, I think I've testified as guardian ad litem in trial on about 3 or 4 occasions. And I will tell you that most of the time, as you all know as a practitioner, most cases settle. And most cases, when they have a guardian ad litem report that's well done and well researched and read by the judge and essentially endorsed by the judge as being good, will settle. So I've done far more GAL reports that didn't go to trial because I think I do a very thorough job and present the analysis in such a way that the parties can understand it, the lawyers can understand it, the judges can understand it, and it promotes settlement. Because you know that most cases settle.
Yes.
And that's what I do as a guardian ad litem, and frankly, it's what I would continue to do as a judge. The system will not be able to function if every case has to go to trial. People need to know how to get cases settled and get resolved.
Would it be a practice if you were to if you were to be appointed? Would it be a practice if you were to try and minimize the amount of cases that go to trial by making sure that only one parent copies toward full custody?
Say that again, please.
Sure. Would it be part of your policy as a sitting judge in probate and family court to make sure that your cases went to trial by ensuring that you developed a reputation for awarding sole custody to either parent? Now, as a guardian ad litem, did you ever take any classes to train to be a guardian ad litem?
I have attended numerous MCLA trainings. I've attended trainings that are run by the Mass Guardian Ad Litem's Association and through various law schools for legal education.
Okay. When's the last time that you went to a training session regarding domestic violence and allegations of it in the custody matter?
Does it count if I was on the panel?
Yes, of course.
Okay, so I was on the panel at a training that was run by Suffolk Law School Continuing Legal Education on this exact topic, and the specific overlay was cultural issues as it impacts on these allegations. And I believe the panel was in February of this year, February of 2010. I'm trying to remember because I had an overcoat, so it was toward the end of the winter.
Okay.
And it was at Suffolk Law School Continuing Legal Education, and the panelists included psychologists, social workers, attorneys, 2 judges.
Have you, in any of the classes that you've gone to or conducted, have you noticed, has there been any trending towards full legal custody in cases where there's allegations of domestic violence?
In the classes or courses?
Right. Is a policy development regarding high conflict divorces?
That was not discussed at the seminar.
Okay, and none of the classes that you've taken?
They did not discuss that.
Have you noticed any trending in awarding full legal custody as a way to kind of terminate a high conflict custody litigation?
I have not noticed the trending.
And how many in determining whether or not there should be joint legal custody, let me state that. Is there any line of cases where you can gather what the legal standard is for awarding sole legal custody, strictly legal custody?
Is there any case?
Any line of cases that you can recall regarding what the legal standard is for awarding sole legal custody?
The standard is the best interest of the child.
And what parties, how does conflict and what sorts of conflict are going to tend to undermine the best interests of the child?
Okay, there's almost always conflict in this divorce or custody dispute. There's almost always conflict. So among the factors that would be significant would be how much they involve the child in the conflict, how much they're able to keep the child separate apart from the conflict. Another factor would be whether or not the parents are seeking to move toward addressing the conflict and resolving it. And sometimes in the very beginning, there's a lot more anger and animosity than there is as time goes on. So what are people doing to help reduce the conflict and remove it as a factor? And how much is one parent trying to undermine the relationship of the child and the other parent? Because I think that those are significant factors that relate specifically to conflict. Having said that, there are 21 or 28 other factors to consider in regard to the best interest other than just the area of conflict. In the area of conflict, whether or not they're involving the child in the conflict, how they're moving to get past the conflict, and whether they're using the child against the other parent within that conflict, I think are three of the significant issues, but I'm not ruling out that there are others that are also important. As you well know, the cases are very fact-intensive, and if I stand here and hypothetically give you these kind of notions, obviously I could think of, and you could think of cases where there are other factors that need to apply, so I don't want to say that categorically those are the only factors one would consider.
So are there any areas, does it matter what the parents are arguing about? Are there any specific areas that are more important or less important to the court in determining the best interest of the child?
In any given case, there will be issues that get greater weight than other issues.
Okay, but there are other matters such as religion, education, health and welfare of the child. The arguments are regarding those areas. Do you have any authority regarding whether or not those areas have any special importance in determining whether or not the child is in custody or solely?
All of the factors you mentioned need to be weighed and considered. No one single factor is positive.
But also areas of those.
Having said that, there's an exception to every rule. And there may in fact be a case where one factor is so compelling that it might outweigh all the others. But that would be a very rare case. It would be a very unusual case.
Okay. In the outline of cases the kind of cases you handled, I may have missed it, but I didn't notice in your list that you provided in your opening whether or not you've done any work in the domestic violence area, in other words, restraining order cases. And I apologize if I missed it.
Yeah. It's not, I know that there have been cases in the past that I've been involved with where restraining orders were issued. It's not been a core part of my practice, and as you know, frequently the people who come in to seek restraining orders do so pro se. I would say that more than half of the people who come into the probate and family court seek restraining orders are doing so without an attorney.
Okay, so during your divorce, let's talk about just your divorce case. Well, let me back up. So you've never been hired just to handle a restraining order, as far as you remember?
There's nothing that leaps to my mind.
Okay. And then in divorce cases, let's start strictly with that. Has anybody in the course of your representation of them either sought or defended a restraining order in any of your divorce cases? I mean a domestic violence 298 restraining order, not a vacating order.
I'm sure.
Okay. Can you give me a number? 5, 2?
I can't give you.
Okay. So can we say that it's been a very, very small
Yes.
aspect of your
Yes.
practice? Okay. Now, how many men and versus how many women percentage-wise do you represent in divorces?
I cannot give you a percentage. I don't know. I don't record data by gender. I have represented men, I represent women. I can't do it.
Okay. How many divorce cases do you handle in a year?
In the last year, in the last 3 years, all of my work in divorce cases in the last 3 years, other than some uncontested ones, has been as guardian ad litem or as court-appointed mediator, neutral, or special master. So in the last, I'm going to say 5 years, all my roles in GAL have been much more like a judge. I've been the neutral. I've been the person except in some 1As, which are uncontested divorces where it comes with the parties.
And all those reports are sealed, right?
Which reports?
Your GAL report.
I don't think they are. I don't think they are.
You don't think that they're sealed at the probate and family court? You think
They're-
they're not going to?
No, they're not, well, when you say sealed, they're kept up in the registry.
Right, they're not available to the public.
Correct.
And did you provide any of the GAL reports for any of your cases the last 3 years to the Judicial Nomination Commission when you applied for the position?
No, I did not, and they did not ask for them.
What about prior to the last 3 years? What was the nature? Did you have a family law practice prior to the last 3 years?
Yes, and I don't want to worry about having read my...
I sure
Okay.
did.
Right.
So prior to the last 3 years, did you, how many years did you, how much you, I saw that 60% of your practice was divorce. Now let's talk about...
60% is family law and probate law, is what the category is.
Sorry. So of your family law and probate law practice, how much is divorce?
At this time, or over the
No,
course of the entire...
prior to the 3 years that you were in jail.
I would say 20%.
20% of the 60%?
20% of the practice.
20% of your total practice?
Yes.
Okay. And so the other 40 or so, well, one...
That would be 80%, right?
I don't
20%
know.
of the total.
I don't know. So what about your state practice? And I don't mean just drafting wills and things like that. I mean, litigating wills. You just say that you were involved in
Will contest, yes.
and will contest trust litigation, that sort of thing. How much you practice with litigation with respect to probate?
Well, maybe I should clarify. When you say what percentage, you mean time, you mean by revenue, you mean the total number of cases? I'm not sure how.
However you can say, however you'd like, and then you can explain what you need.
I think it would be easier to say roughly 3 or 4 cases a year.
Okay.
That may be the easier way to say it.
All right. And so prior to, so how many divorce cases a year did you have prior to this last 3 years in your jail?
We need to go back. We need to go back to when I was actively representing the litigants as opposed to serving as a neutral.
That's correct.
Okay. Let me think for a moment. On a given year, I would say between 10 and 30 cases.
Okay. Now, how much of your practice is court-appointed work, fees that where you get,
Currently or historically? I mean, in the first 10 years of my practice, I would say probably a third.
okay.
In the last 10 years, I'd say probably 30.
Okay, so the GAL cases are private pay cases then?
More often than not, yes.
Okay, you're appointed by judges?
Yes.
You're not selected by the parties?
Both. But I'm appointed by judges. It may be by agreement of the parties.
Okay.
Ultimately, the appointment comes from judges. But often it is by agreement of the parties or request of the parties, yes.
Okay. And when you were involved in the Department of Social Services, did I get that right? It was DSS, right?
It was DSS at the time. It's now the DCF.
Okay. When you were involved, did you do investigations of daycare facilities during the 80s?
No, that was the licensing was the Office for Children.
Right. Okay. So did you do it for the Office for Children?
I did not do licensing investigations. I was an attorney for the Office for Children. They were licensors who did licensing investigations.
Okay. So you weren't involved in any of the prosecutions or investigations regarding any of the daycare facilities?
You're asking 2 different questions.
Yes,
Investigations is different from prosecution.
Yes, I am.
Okay. I was not involved in any investigations. If the licensors determined that the facility needed to have its license removed, it would be referred to the legal office, and the legal office would become involved in the prosecution.
Okay. Were you involved in any of those prosecutions?
Part of my job was to be involved in licensure, and I was mostly involved with family daycare and a couple of, this is going back a ways, I have to think about not involved in the high-profile case at that time.
That was one of them.
Bell Baker, yeah, I was not involved in that one in any way.
Were you involved in any of the other cases where people were incarcerated for abusing children in daycare facilities?
No. And that would, you understand, would have been the district attorney's office to prosecute those cases, and I was not involved in any of those.
Right, I do understand that, but there is that middle ground where a case investigated and put up the chain, as you pointed out, to the legal office.
But if I may, that's only related to the licensure, not to incarceration.
Okay, so prior to them being incarcerated, I'm assuming their licenses would be pulled for operating daycare facilities?
The license would be revoked, yes.
And did you involved in any of those cases?
Yes, but not the high-profile ones.
Were you involved in any of the cases where the licenses were pulled and then they went on to be criminally prosecuted? With respect to probate work,
Yes.
what type of have you addressed a will that's been challenged, or a trust, or power of attorney, healthcare proxy, anything like that?
Not that I recall.
Okay. Have you been involved in a case where a lawyer's perception of whether or not a client has the requisite mental capacity to sign a will or testamentary document? Have you ever been involved in such a case?
Where that was one of the issues?
Yes.
Yes.
And have you ever made a challenge to a lawyer's perception of whether or not someone has sufficient testamentary capacity or donative intent?
Are you asking whether I made that challenge or whether I represented someone else who made that challenge? Which are you asking?
I'm asking you, role as an attorney.
That's what I have made the challenge.
Yeah, in your role as an attorney. You represent somebody who made a challenge against a lawyer.
Okay, so you're asking if I represented someone else who's making the challenge, not if I made the challenge. I just want to understand your question.
Well, I'm not here to ask you about whether or not you've ever challenged anybody's will or family. I mean, I'm asking you if you've ever represented somebody who made a challenge.
Yes.
Okay. And you feel comfortable challenging an attorney's point of view as far as whether or not this person has the requisite mental capacity?
Yes.
What's your position regarding, I also noticed from your background that you provided us that you work with the Department of Mental Health? Is that right?
Yes.
And that I'm assuming that you're involved in forced medication as far as issues that involve forced medication?
I'm sorry, I'm looking at forced medication.
When people need to be medicated, they need to have guidance appointed for them or determine whether or not the person should be medicated for mental health reasons.
So you're saying medication of...
I don't just...
I want to understand your question. When you say forced medication, you mean medication of people who are not competent to make the decision themselves? Is that what you're saying?
The question is whether or not they're competent. Yes, and if they're determined to be incompetent.
I've been involved in thousands of those cases.
Okay. So, on what end of the case are you involved? Have you been involved on behalf of the patient? Have you been involved on behalf of the Department of Mental Health? Have you been involved on the Department of Family Members?
The answer is yes.
To all of them?
To all of the above.
Okay. So
Hundreds of times in every role.
Okay. So do you have any particular interest or point of view as far as advocacy in favor of or against the medicating of people who need mental health?
Yes, I have a strong position.
Would you please share?
Yes. My position on that issue is that the law is very clear and that both sides should have attorneys who advocate zealously for the interests of their client, and it's up to the judge then, after hearing that evidence, to make a determination as to who is carrying the burden. The burden in regard to medication is to demonstrate a case by a preponderance of the evidence with written findings of fact to support that. So it's a little bit higher than the usual civil standard. The court must make a determination initially whether or not the individual is competent. If the court determines that they're competent, they make their own decision. If the court determines that they're not competent, the court then applies what's called substituted judgment, substituting the judgment of the incompetent person. The judge stands in the place of the incompetent person and says, this is what that individual would want if he or she were competent and could understand his or her incompetence after considering the factors that are prescribed by statute and case law, which include prior express preference, side effects, prognosis with treatment, prognosis without treatment, impact on family, and other factors that are enumerated by the case law, and that every one of those issues has to be addressed by the court, and the court then makes a decision. And the law should be followed absolutely in every one of those cases.
Is this an area that you have more constitutional experience in than perhaps in the other areas that you have in the board?
This is the area of law where I write the chapters that are in the books that are given to the attorneys to read.
Okay. So, with respect to the actuarial aspect of a mental health case, and we're talking about, I think we start off by saying the actuarial system, whoever needs to improve the judge and make the determination. What is, how much does it weigh in whether or not does it weigh in, and how much does the nature of the representation of the mentally ill person, quality of the representation of the mentally ill person?
Are you asking if a good lawyer is more effective than a bad lawyer?
No,
I'm trying to understand what you're asking.
Sure. I'm asking as a judge, do you feel that there should be a need to factor in whether or not a mentally ill person is getting effective representation before determining whether strictly whether or not they've met their burden of proof for an incident?
I have to apologize because I'm still not sure I understand your question. Are you saying that should I, as a judge, bolster the case of a lawyer who's not doing a very good job? Is that what you're asking?
In that case, yes, when somebody is with their constitutional rights are on the line and they're going to be medicated, and it's not what they want.
It's an interesting question. If I, as a judge, feel that I'm not getting the information I need to make an adequate decision, I will not substitute myself and become the attorney and do what the attorney should do, but I will take an action, and the court has authority to appoint an investigator or guardian ad litem to look into the matter and make recommendations and provide the information. So I would not substitute myself and take over the job of a counsel who I felt was inadequate. But I would have a couple of remedies if I felt I did not have the information I needed to make the decision. One might be to appoint a GAL investigator, one might be to appoint a successor counsel. But I would not take on that role and do what I think the attorney should do.
Okay. Let's talk about appointing a guardian ad litem then. When you've given a recommendation regarding the GAL recommendation, how often has the judge always followed your recommendation?
When I make a guardian ad litem report?
Yes.
No.
Okay. And how often does the judge follow your percentage? How often does the judge follow your recommendation?
Let me tell you that most of the time the case settles in the judge's hands of an agreement. So way more often than not, that's what happens usually. When there's still a dispute and my GAL report is put into evidence, I would say that in the history of my practice, it's probably been more than 98% of the time that the judge has agreed either entirely or substantially with what I recommend. There have been a couple of times when they have not.
And isn't it also, do you agree or disagree with the following statement, that once you've done your guardian ad litem report, given the fact that there is 98% chance that they'll be followed by the judge, that your report as a guardian ad litem can influence the settlement?
Do I agree with?
Can encourage the settlement.
Do I agree with or disagree with that? I agree that my report can help influence and encourage someone. Yes, I agree with that.
So,
and I think that's a good objective. I think that goes to your earlier questions about conflict. If people can make an agreement and own the agreement, there's a better likelihood that it'll have a long-term better outcome than if it's imposed on them by someone else. But if they're unable to make that agreement on their own, I stand willing to do the hard job of making that
Now, as a judge, how much weight are you going to be giving the guardian ad litem report?
Well, you're asking a question that is kind of in a big vacuum. I'd like to see how good the report is and what it addresses before I answer that question. And I'd like to see what the credentials of the GAL are and how thorough their investigation was and what they did. So I can't answer it without knowing quite a few more facts in your question.
How much are you going to be looking into the basis of the guardian ad litem decision? For example, let's say the guardian ad litem, let me give you an example. The guardian ad litem writes a report, very well researched. The guardian ad litem doesn't understand the legal standards for awarding joint custody versus sole custody. Would you look at that and weigh in whether or not the we should follow the guardian ad litem's report?
If it's poorly done and reflects some fuzzy thinking, I don't think that I'm obligated to apply.
You're certainly not. Okay, I'm just wondering whether or not I think you did.
I think I have to. This is J.D. Cherry, my friend who works for the Court and Attorney Department. Thank you, J.D.
I think that's all I have. Thank you very much.
Thank you, Counsel.
Thank you very much.
Thanks again for all the time you took with me. I think we covered everything when we spoke. I'm not a lawyer, as you know, when we met. I told you that. I think I wanted to tell you that I appreciate your talking about your family and your roots. And it reminded me when you talked about the mop stick that they used and playing baseball. And my late husband, when he was growing up, they used a bushel basket on a pole in the street when they played basketball. So I could relate to that story. First of all, I want to commend your witnesses. They all came for a different perspective, for you are professional, and they were all great. And I especially appreciated some coming after 11 years, that the impression you made on this young man as a coach. I think that's should be noted. As you can see, I crossed out all the things that Councilman was asking you a question, so I'm trying not to be redundant because she covered a lot of other things that I wanted to ask you. First of all, we talked about the number of men and women that you have represented. It must be 50-50 because you couldn't, say more men or women. The other thing,
some of my office ever here know evidence. Our record keeping in that regard is not particularly refined.
Right. Now, as far as you talked about domestic violence, and we know that unfortunately, and I'll say women, accuse their husbands falsely, even under oath, and you replied that you, a judge, have to address that, to look into it, to make sure that what has been said is factual. How would you do that?
One of the important parts of judging is to ascertain credibility, to determine credibility. And I took a special handshake. I'm not allowed to tell you exactly how to do that, but there's an experience that goes into that. When you practice in court for a long time, you learn about certain things that witnesses do and say that are not credible. And you look at consistency of their statements and you evaluate that. And it's one of those things that I think you get with experience. And having imposed a number of people over the years and having cross-examined people and having subjected them to direct testimony. observing witnesses and I'm observing judges, and you get to a point in time where you get to have a pretty decent skill at being able to tell when someone's credible and someone's not. And it's not perfect. It's not perfect. But the more you do it, the more experience you have, the better you get at it. And you don't try to rely on just one channel. I don't just listen. I don't just look. I don't just read. I try to do all those things. I try to match up different versions of events and try to look and see what really seems like it makes sense.
Okay, in your opinion about restraining orders, how would you recommend that they should be administered? What kind of things would you take into consideration to administer?
I'm not sure. When you say administer, you mean to issue it?
Yeah, and what evidence do you need? And like you said, you use that as your own gut feeling, maybe a whole lot of things. It has to be beyond that.
It's more than a gut feeling. It's more than a gut feeling. It's being able to assess the credibility of the factors. To assess the credibility of all of the evidence, not just documents, but statements, and behavior, and conduct, and witnesses. There are quite a number of factors that we look at to determine who is more credible, who is more believable.
I mean, documented evidence.
It's more than just a gut feeling.
Right. In chain custody, how many cases have you had that you have seen shared custody?
Well, most cases end up with some form of shared custody. That's the result of most cases. The ones that we're hearing about that are causing some distress are the cases where there's not an agreement and the parties can't work it out. And I don't know where that 80% figure came from. I don't trust statistics if I haven't read the background and the way the statistics were developed. But I can tell you that in most cases, and I'm going to make up a statistic here, well over 90% of the cases that come into the probate family court ultimately settle, and they settle with some form of sharing of legal and physical custody. So that means fewer than 10% cases don't result in that by agreement. And then some of those cases go to trial, and after trial, many of those result in some form of shared physical or legal custody. So it's a very small percentage of cases that result in something other than shared legal custody. It's a very small percentage of cases that end up going to trial. So,
well, I met with members of the faculty group, and I've met with a couple who haven't, a couple of men at least, who told me that they haven't seen the children in 8 years, 10 years, and it just seems like, you wonder if that judge made a mistake in these cases, and there was false accusations, and accepted as true, and so they're going to be punished from not seeing their children, our relationship with them. I think that's a concern that I have.
those are sad and unfortunate cases, and the probate family court has many sad and unfortunate cases. And without knowing all the facts about those particular sad and unfortunate cases, I can't tell you any more than that they are sad and unfortunate cases.
And do they have any appeal process for that?
There are appellate courts in the Commonwealth of Massachusetts, there's appeals court and the Supreme Judicial Court.
Your experience in probate family law is 65%, and basically that 30% civil?
Yes, and those tend to be actually district court cases that are very, very related to probate and family court. They're mental health cases that happen to take place in the district court. So they're similar issues, just in a different form.
Right. How about removal of children? Can you cite one example of a case, just, briefly, how that happens? I mean, what kind of, it has to be extreme, really.
With regard to removal of children, I personally think those are among the most difficult cases that come into the probate family court. I'm a father, I have 2 sons, they've lived with me my entire life. And I've been appointed as guardian ad litem on these cases. And they're the most excruciating, difficult cases. And they get incredible attention and focus and detail because of the significant consequences. The truth of modern society, and this is one of the issues Solomon did face, is that we live in a highly mobile society, and we
We live in times when the economy isn't always great in one part of the country that may be better in another part of the country. We have a very mobile population. I live 300 miles from my parents. My older son works now for me almost 3,000 miles away. We live in a very mobile society. People move and people leave areas. And it's very sad when families have broken up. And a child lives with one parent and not another. And the parent with whom they live then needs to relocate for economic or other reasons to an area which now will make it impossible for both parents to have regular, ongoing, frequent contact with the child. Those are very, very difficult cases. And the case law is very clear in terms of how it's resolved and what's done. And the case law differs before the divorce is final and after the divorce is final and the custody has been awarded. In the first instance, we rely on the Mason decision. That is, if it is pre-divorce and the custody has not been determined, then they look more at a standard best interest test with a presumption that the child should stay where their roots are. Post-divorce, when one parent does have custody, if that parent wants to be removed, the standard is what we refer to as the real advantage test. The parent who wants to move has to establish that they have a sincere, good faith reason for wanting to move. They're not just trying to go away to deprive the other child of the parent, but there's a real reason, such as a job move, or perhaps they remarried and their new spouse has been transferred, perhaps they're in the military. But there's a legitimate, real reason to move, and then, besides establishing that, then they need to establish that there would be a real advantage for that parent, and then the presumption that follows from that is it would be best for the child to be with a parent who is happy and can have a reason. So that's what the law is. And you have to look again at the very specific facts of the case to determine how that law is applied. And I will tell you, those are very, very difficult cases, but difficult cases are the reality of probate and family court. And I'm taking this job, I'm seeking this job, because I'm prepared to do these difficult kind of things and to make these decisions with sensitivity, with respect, and with regard to the parties and the facts. Someone will need to make these decisions. Someone will need to have that judgeship. I feel that it's a great challenge, but I want to take that on. I want to be prepared to enforce the law and apply it to the facts.
Well, can I tell you that's not always applied, and I told you as a judge to what you said the law is, but I'll just...
I mean, if you're asking me now what other people would do,
no.
I can't answer
well,
that. I can answer you what I would do.
Yeah, I'll just tell you, about 2 years ago, a judge, a woman who was approved by his counsel, 2 years ago, and I read in the paper, and I was heartsick. She had a case of custody case where the father was a very good father. He came and read to there were small children, the rest of them every night. But that he was dedicated, committed father to the children. And she made a decision, the judge, to allow the mother to move across the state. I mean, he couldn't go in further in the United States to move. So this was vindictiveness. I mean, it was obvious. Looking at it and looking at the, the documentation, first of all, she had no family there. She had no child waiting for her. Her family were all here. And it was simply to disallow the father to see the children. And I know, okay, it's laws can be banned and everything. I'm not saying this is going to happen to you, but I'm just saying I know that it does happen. And do you know what she gave him for visitation rights? She gave the father 1 hour on the internet, 6 to 7, every day. The children. And you can't have a computer, and this is the communication he would have with the children. So, virtually, he's lost all communication with the children. And he has a job here and to travel across the United States. So I'm saying that, we know the law. And I have been very disappointed in some of the judges that have come through here and been approved that they don't apply the law. They apply their personal opinions on things. And that's the thing I'm very, especially now, we live in an age that I never thought we'd see. I mean, we've got, like you said, who gets engaged, should they be destroyed, stripped, don't have 2 fathers, 2 mothers. I mean, judges have met 20 years ago would never be, had this presented to them. And I have to say, very frankly, I am very pleased with your background that you have more experience in dealing with these things than most prospective judges that come before us. But I'm just saying, it doesn't They don't always apply to law.
And I can just say to you, I don't know if this has ever happened to you, but I've been misquoted in the newspaper.
Oh, please.
So it makes me sometimes when I read the newspaper wonder how accurate things
I
are.
wish they was my name.
Okay, thank you.
I understand that, but I'm just saying that, things aren't absolute.
I understand.
And not all judges are equal. And I'll ask you, what have you learned from bad judges that you won't do when you're
Well, that assumes that there are bad judges.
Oh, I'm not asking for names, you give me initials.
Different people have different styles. One frustration that I've heard from some attorneys is judges who are slow to issue decisions, and parties wait and live in kind of a time of uncertainty. And sometimes people just need certainty. So one of the big challenges I would hope to do is not to make people wait for decisions that are so important.
The thing that I feel very strongly is that the judge should represent the people who come into court, and to have the compassion, for that person and respect. And sometimes it just doesn't always apply, so that's why I'm pleased with the in talking to you that family is very important to you, and you have sympathy for people going through divorces and custody cases. Trying to wait through all the things that are crossed out now. Okay, what would you say is the most rewarding outcome of a case that you have in your 24 years of experience?
Probably there have been several cases in which, when I've worked with someone through a great deal of stress and conflict and difficulty, and we've come through it, and by the end of the case, they're a little bit less angry, they feel a little bit more control of their lives. I can think of several people I've dealt with over the years who, when it's over and they're ready to move on, I think that's a pretty good outcome. I can't give you one specific case, but that's kind of the general feeling. They come in very hurt, very angry, very disgusted or frightened, and they come out of the other end with some sense of self-peace.
On the other end, when something that you're so passionate about and you really believe in your client and everything, and it didn't go your way, is there something that some of these cases don't stay with you? I mean, you have to be, careful and not to. Is there one that comes to mind?
I think the times that I lose the most sleep are before the case goes to know, this is so important that I'm fighting for someone's issues, and that stress and that tension, putting it all in before. And then when it happens, when it's done, if there's a bad outcome, I do my very, very best. It makes it a little bit more palatable, and then I try to work with the person and help them to adjust to or adapt to that fact. But more of my anxiety or stress or tension comes beforehand. Have I done everything I can? And that's when I lose sleep before the trial as compared to afterward, because if I know I've done everything that I can, I've done my best, that's just a good outcome. Sometimes in these cases, someone does have to lose them, and that's part of the reality of the adversarial system, and then it's a question of helping them to move on with it. And I can feel disappointed, but then my goal there is to work with them and help them to move on from that disappointment.
A couple of points I wanted to make that I was impressed with. There's a question in our questionnaire, general charge of your law practice. I have never seen in my 10 years as a government counselor 2 pages full. That is very impressive of your background, and especially going to this particular court, mental health law, family law, estate, guardianship, paternity actions, domestic relations, child custody, the elder reviews, all of these that that you bring to the court. When I read this, I was just very impressed, because we don't see this. We don't see all that in 24 years. You really, it's really, how should I say it? It's really aimed to me in this court.
Thank you.
What I look for is someone with experience on that court. I want someone, that's been in, at least court, experience because, I've seen some people come through here, they just want to roll, they don't care where, and that's not what it's about. It's very important to me to have the right person. I was impressed with that. The other thing is, always willing to learn and educate your colleagues, and I was very impressed with 3.5 pages, and I've never, ever seen that, of legal seminars and training where you've been a participant, you've been a panelist, you've been a moderator, and presenter in these education programs, and I thought that was fantastic. I really, so those two things really stood out that I haven't seen before, and that quantity of knowledge and experience, and I think that I'm pleased with your background. I just feel that again, with the file, we talked about that, and I hope that you can meet up with them, have a meeting or some kind of thing to we can't promise everything we're going to do. Every case is different, but they have a certain issue, and I think you were sensitive to it when we spoke. You were, and I did feel that, and I want to put that on the record. The thing is that, it has said in the impact that can't separate the professional from the private person, and when you talk about your family and admit to them, I think you bring that to the court because you care about, children and your background has been in human services. And I particularly, I served on a commission on disability for 24 years, and I was especially, when you talked about your family, I made it up as I was to disabled, grandparents. So I think that you bring all of this, and it's life experience that you're bringing with the, experience you got as an attorney, and I really am pleased with that. I'm going to, I have confidence in you, and I don't think you'll let me down in all those talks that you said to me, and I'm going to be very pleased to vote for you next week. I don't have a poker face, I never have, so I'm going to say that right off. And I'm looking, and I think everything was covered by Council Manning that I had questions about. So, I wish you all good luck.
Thank you very much. Thank you.
And I have to say, this is your first time that you have applied.
Yes.
And, and you applied to the right court.
Thank you, gentlemen.
Hey, just a couple more things. I appreciate that members of your audience may be aggravated. I understand that this is really important stuff that goes on in the court. So just bear with me just a few more minutes. What's the legal standard for issuing a restraining order?
There has to be imminent fear of harm or evidence that someone has suffered abuse, and the statute defines abuse, and I can't give you every sentence of the statute, but it relates to fear of physical harm, forced or coerced sexual activity. But it's right, it's clearly stated in the beginning of the statute what the definition is, and that the person either has experienced it or has imminent fear of that.
Okay. And does it have to be severe harm?
Serious, I believe, is the word that's used in the statute.
And who wrote your letters of recommendation to you? Or did you have any letters written by you to the J?
I had 10 letters written to James.
And you might know who they were.
I will try to remember what the top of my head. One is John Fisk, who's kind of like the Dean of Family Mediation in the Commonwealth of Massachusetts. He's an attorney in Cambridge. One was attorney Mary McGee in Lynn, Massachusetts, who's a small practice over there. One was, Her Honor, Judge Borstein. I think you had dealt with it. One was Justice Ted Donnelly of the Middlesex Probate and Family Court. One was Justice John Smoot of the Suffolk Probate and Family Court. One was Attorney Robert Weber of Newton, Massachusetts, who's one of the premier or preeminent mental health attorneys in the state. One was Judge Bonnie Mancuso McLeod Griffin, who was a Superior Court judge, but I knew her when she was the District Court and Juvenile Judge, who presided over many of my cases. Another was Judge Carol Erskine of the Worcester Juvenile Court, who had worked for me as an attorney when she was at Dare Family Services, and also was a law student of mine when I taught at Suffolk Law School. And there were 10. How many names did I give them? Well, I like to go tell me there were 4 men and 4 women. If you could tell me how many.
It was 1, 2 women, 3 women.
Justice Randy Kaplan of the Middlesex Court, County Court. And
1 man left.
Weber, Thomas, and Smoot. I'm trying to remember what his definition is.
Go for extra credit.
But I just want to make it clear, A-minuses are not what we strive for.
Now, have you ever had an appeal? You ever done an appeal?
I've done a couple of interlocutory appeals.
Okay.
And I was always, when I was in first or second year as a DSS attorney,
Right.
someone took up a case on an interlocutory appeal. I was, I had one below, I had one above.
Okay.
I had one when I was in early 90s, shortly after I started there. In fact, Judge Mancuso McLeod was the judge. It was the first time she was ever taken up an appeal, and we were successful in that. And there was another time on an interlocutory appeal. Oh, I did a private adoption. I represented an aunt and uncle who had adopted their son and the bio mom, but I'm an interlocutory appeal. And I don't do appellate work.
Right.
That's not the gist of it.
Right, so, you mean, but after a full trial, you haven't appealed it to a judge, you haven't done any appellate work.
Correct.
You haven't.
Correct.
And.
Part of that's because I didn't a lot of times, so you don't get to appeal, but.
Right. Right. Well, we don't have to worry about that anymore, right? All right, so, for the things that you used to counsel today, regarding the questions on removal,
Yes.
I kind of got lost a little bit there. That's not unusual, but I just want to ask you, did you talk about the impact of joint legal custody and whether or not it impacts the judge's decision as to what the standard is for allowing the removal from the state?
I did not.
Okay, I didn't hear you do that, so does that impact the analysis at all?
Yes,
Whether or not it's already joint legal custody?
yes, but then you'll have to do a complaint for modification to modify a legal custody as opposed to a removal petition. And there was a recent case which was actually misfiled. It was called a complaint for modification, even though it's a removal. It was called a removal, even though it's a complaint for modification. But essentially, the appellate court said they would apply the same, the real advantage standard with regard to that case.
And the real advantage standard was when that was joint, instead of joint legal case?
Yes, in that one it was.
Maybe I misread the case, or a case that I think is misread. Maybe I misread it. It seemed to me that it was.
I'll consider that possibility.
Yeah. Okay, so seems to me that in a line of cases for removal, that the court is now severing legal custody, joint legal, in order to apply a different standard for removal.
Oh, you let me think of the Prenival case,
It's possible.
which is different from the case I was talking about. I can't think of the name, the one I was talking about.
Prenival v. Prenival?
Prenival is the one
You're thinking of Mason versus...
No. I'm thinking one much more recent than that. But you're thinking of Prenival, and I'm thinking of the case.
I think you're right, and I don't think it's
You're
Prenival.
thinking of Prenival. I was talking about another one because one of the issues the appellate court addressed was whether the fact that the pleading was misfiled should be dispositive of the outcome. And they said whether you call it removal or whether you call it modification, we're going to treat it as removal. And Prenival was, I think, a very complicated decision, and
Isn't it just outright wrong? I mean, why should the court be allowed in a case where people have joint legal custody to say, well, you know what, one of the parents wants to move out of state with the child, and both parents will share legal custody, but you know what, in order to make this an easier decision for us, we're just going to sever joint legal, we're going to make it sole legal, and now we'll apply a lower threshold for I don't know which parent it was, for one of the parents to move out of the state with the children. I thought that was just outrageous.
I think the appeals court made it a little bit confusing in their analysis, frankly. But they did remand the case back to the trial court.
Right.
And I believe that after the remand, the children will in fact be moving out of state. And in that particular case, they'll be moving out of state to be with father.
But wasn't it
They'll be moving out of state to be with father.
But wasn't it a removal
what happened was,
It wasn't a specific finding or something.
the trial court made a conclusion that it would continue to, he didn't want to call it shared or sole legal or custody. He said, I refuse to apply, to use that terminology. I will just tell you what the schedule is. And when he spelled out what the schedule is, the appeals court said, no, we don't like the schedule, and we don't like the fact that you didn't really label it what it was. And that's part of what muddied up that decision, was because the appeals court didn't like the outcome of the trial court, nor did they like the way the trial court framed it.
Maybe it's
So
not,
it got sent back on remand.
maybe it's not credible that I'm thinking of, but, what is your position with respect to removal? Should you make a determination first, rethink the joint custody, or should you stick with what the custody situation is, and then decide whether there should be removal?
Again, I think you have to look at the facts of the case. For instance, Prenovo involved a move just across the border to New Hampshire. You can analyze that differently than a case that involved a move.
That was 5 hours away, if I recall. She had to stay in a hotel or wanted to.
No. I can tell you the specific facts of that case. It wasn't 5 hours away. It was 2.5 hours away. Her father had vacation home in New Hampshire, which is why the judge said the kids should primarily go with dad, and on the weekend, when mom has them, the kids won't have to travel back and forth from Canton to New Hampshire, but mom can go to the vacation home in New Hampshire, and the children have less travel. So this is what I'm saying. Cases can be so factually specific and intensive that to say globally what one would do without knowing the specific facts involved is a dangerous thing to say. That judge had a lot of factors that caused him to believe that removing the child to New Hampshire to live with dad was what would be best for the children. The appeals court disagreed, and they re-articulated the standard. They kind of made a hybrid between the Manning standard and the real advantage standard.
What I heard you say, and I really don't want to be unfair, so I want you to have an opportunity to correct what I thought you said. What I heard you say was that whether I apply a particular legal standard is going to depend, regarding the federal joint legal custody in the removal case, it's going to depend on the facts of the case. I think the legal standard is the legal standard, and how the facts shake out is what.
That's what I meant to say. How I apply it, not apply, but how.
Okay.
How you apply the facts is of course the.
I just want to make sure that.
Yeah, with how. If I misstated it.
No, I may have misheard you, that's okay. Thank you very much.
Thank you.
Mr. Chairman.
A point of clarification for those present, talking about the letters. Governor Patrick, in his executive order, invites the nominee to have people write letters of recommendation to them. So you may not know that, because this is the first time ever in the governor's, the governor's instructions. Now, when I spoke to Attorney Aptaker, he was very open about the letters and verbally told me about who sent them and was ready to provide them.
If I may, I'm sorry.
Sure.
I want to get a 10 out of 10. District Court Judge Lee Johnson was my 10.
Too late.
He's told me. Thank you. I'm sorry. No.
So,
9 and a half.
Council's being something important.
I'm sorry. I apologize.
I just wanted to say, to put on the record of this hearing that we did discuss that, and I told you my opinion, and you were very willing to provide them, and when you verbally told me that was it, and we did discuss a lot of things at length. But regarding the letters, I have filed legislation that these letters be made public and placed in the State House Library, simply for transparency. We don't see those letters. There's simply no reason for this nominee, and I only know this nominee talked about today, and get no problem with it. But what if other letters of people of really, weigh in very, highly with the JNC, it could be unduly influenced. And so I think it's important that they be made public. And it's, to me, very egregious that we don't get those letters. Imagine the judge sent a letter, and I don't even see it, and for the other people to get the letter.
But I'll tell you, nor do I. Nor do I see it. It goes directly to the JNC.
No, that is the point. We should see that. We're voting on the nominee. So I just wanted to, just to inform you that you might not know what the letters mean and what was brought up. So I do want to put that in the record, and hopefully the legislation will pass. I don't know. I hope so, but that's it.
Thank you very much.
Thank you very much.
Now, I'm just going to wrap this up with a couple of comments. I don't have any questions. It's really very obvious to me, based on the past couple hours of listening to your very excellent witnesses, very diverse in their experiences and input, as well as your testimony in response to a wide range of questions and inquiries that the governor made an excellent choice. You have a tremendous experience, unique experience. You're very familiar with so many facets of the work we've done before the probate and family court, and it's quite obvious you have tremendous insight and points of view about how the law should operate, and I think we're most fortunate that the governor has selected you for this very important position, and the range of the questions and concerns that everyone expressed here today show us the importance that this position and these positions have on the day-to-day lives of families and Wilmington rentals, and I'm very impressed.
Thank you.
Your nomination will be voted on next week, and I wish you the best of luck and best wishes.
Thank you.
All right,